Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Chicago, Illinois. Class 2 felony lawyers. Being arrested for or charged with a Class 2 felony in Chicago, Illinois is serious. A felony conviction can mean high fines and years in prison, results that can have an outsized impact on your life for decades afterwards. If you're facing a Class 2 felony in Chicago, or anywhere in the surrounding Cook County area, get in touch with the criminal defense lawyers at Combs Waterkotte. We'll speak for you during interrogations, represent you in court, and fight to minimize the impact of your Class 2 felony charge on your life. Class 2 felony lawyers serving Chicago, Illinois, and all of Cook County. When you choose Combs Waterkotte to take on your Class 2 felony charge in Chicago, Illinois, we'll start with a free, confidential consultation. We want to understand your side of the story, all the pertinent facts, evidence, and circumstances of the charge you're facing. After we know what we're up against together, we use the combined resources of our experienced team of attorneys, paralegals, and legal assistants to outline viable defense strategies to take on every detail of the prosecution's charges against you. The key to success is in the details, and we work tirelessly to sift through them all. Throughout the entire process, you'll experience our client-centered approach to practicing law. This means we keep you in the loop about anything and everything going on with your case. Every decision, every ruling, every plea offer, and every detail of the trial process, if the case goes that far. Everything we do from the outset is designed to dismiss or reduce your Class 2 felony charges. If that doesn't happen, we'll aggressively pursue a not guilty verdict at trial so we can add your case to our growing list of victories. If you're ready to fight your charges and secure your future, reach out to Combs Waterkotte online today or call us now at 312-500-HELP. What is a Class 2 felony in Chicago? In Chicago, Illinois, Class 2 felonies are right in the middle of the felony classification system. Their potential penalties are less severe than Class 10 and Class 1 felonies, but more severe than Class 3 and Class 4 felonies. While being in the middle may not sound too bad, you should still take Class 2 felony charges very seriously. A conviction can result in any of the following possible penalties: a 3 to 7 year prison sentence, an extended prison sentence of 7 to 14 years for aggravating factors, possible probation up to 4 years, possible electronic monitoring, 2 years of parole upon release from prison. While Class 10 felonies have no possibility of probation in Illinois, and Class 1 felonies have a low possibility of probation, in many cases, a defense lawyer can negotiate probation for their client with a Class 2 felony charge. That's why it's vital to contact a criminal defense attorney if you're facing a Class 2 felony in Chicago or anywhere in the Cook County area. List of Class 2 felony offenses in Chicago. There are several criminal actions that can result in a Class 2 felony charge under Illinois law. The best way to understand them is through certain offense categories, including weapons offenses. The state of Illinois has some of the most strict gun laws in the country, requiring a firearm owner's identification, FOID. Illinois' criminal laws are just as strict, with many weapons-related offenses meeting the Class 2 felony threshold. Some of the most common weapons charges Combs Waterkotte defends against in Chicago include Unlawful possession of weapons, including unlawful possession of weapons by a felon. Armed violence, for crimes committed with a Category 3 weapon. Aggravated unlawful possession of a weapon, for second and subsequent offenses. Unlawful discharge of firearm projectiles, for carrying certain types of restricted ammunition. Unlawful sale or delivery of firearms, for selling a concealable weapon to someone under the age of 18. Theft and property offenses. There are several stealing and property-related offenses that are classified as Class II felonies under Illinois law. Some of the most common theft and property-related offenses we see charged in the Chicago area are robbery, burglary, when causing damage to the applicable stolen property, arson, theft, for a value of $10,000 to $100,000, or a value of $500 to $10,000 from a school or church. Retail theft, for a value of $300 while exiting the location through the emergency exit. Identity theft, for a value between $2,000 and $10,000, or a value between $300 and $2,000 when the victim is a member of the U.S. Armed Services or Illinois National Guard. Sexual offenses. Cook County and Chicago area prosecutors tend to pursue convictions in sex offenses aggressively. Some of the most common Class II sex crime felonies we see prosecuted in the Chicago area are criminal sexual abuse, for a second or subsequent offense. Aggravated criminal sexual abuse, patronizing a sexually exploited child, if the offense occurs within 1,000 feet of a school. Child pornography, for possessing videos of children under 13 years old. Drug offenses. The Illinois Controlled Substances Act outlines several instances where making, distributing, or even possessing illicit drugs is a Class II felony. Some of the offenses we help defend against most often include manufacture or delivery of controlled substances, for relatively small amounts of LSD, methamphetamine, fentanyl, and other drugs. Controlled substance trafficking, providing or selling drugs to minors within 500 feet of a truck stop or safety rest area. Violent offenses. Given the potential injuries and even deaths involved, police and prosecutors in Chicago are usually highly motivated to hand out the maximum allowable prison sentences under the law for violent crimes. Some of the violent offenses we help defend against most, often in Chicago at Combs Waterkotte, are involuntary manslaughter and reckless homicide, when committed in a school or construction zone or while ignoring directions from a police officer or traffic cop. Kidnapping, aggravated battery, when causing great bodily harm or permanent disability to a person 60 or older. Domestic battery, for those with 4 or more prior convictions. Aggravated domestic battery. Hate crimes, for first-time offenses that take place in a church, synagogue, mosque, cemetery, school, or public park, or for all second or subsequent offenses. What to do if you're arrested for a Class II felony in Chicago? A Class II felony is a very serious offense in Chicago and Cook County, and what you say or do after being arrested or charged can either make or break your case. If you're ever arrested for a Class II felony, the criminal defense attorneys at Combs Waterkotte suggest taking the following courses of action. Remain silent and do not answer questions. After an arrest, anything you say can and likely will be used against you. Even casual or explanatory statements may prove damaging in the long run. But remember, you have the right to remain silent under the Fifth Amendment. Politely decline to answer any question from law enforcement. The only thing you should say is that you're invoking your right to remain silent and that you'd like an attorney present. While law enforcement may continue questioning you, you are not required to respond. Ask for an attorney immediately. Request a lawyer as soon as possible, and do not say anything else until one is present. This right applies during police questioning and other critical stages of your case. An experienced criminal defense attorney can prevent missteps, protect your rights, and begin building your defense strategy early. Comply with law enforcement without resisting. While you should assert your rights, you also should not resist arrest or act aggressively. Resistance can lead to additional charges or escalate the situation. Stay calm, follow basic instructions, and address any violations of your rights later through your attorney and the legal process. Do not consent to searches. Police officers may ask for permission to search you, your vehicle, or your home. The Fourth Amendment says you are not required to consent as long as police don't have a warrant. Clearly and calmly state that you do not agree to any searches. This will preserve your ability to challenge illegal searches later and may prevent prosecutors from using improperly obtained evidence. Do not discuss your case with anyone. Don't talk about your arrest, even with family or friends, and especially not on social media. These conversations are not protected and can be used later as evidence. Even private messages or recorded jail calls may be monitored. Limit all discussions about your case strictly to your attorney. Pay attention to charges and court dates. Make sure you understand the charges filed against you and any upcoming court appearances. Missing a court date can result in a warrant for your arrest and additional legal consequences. Keep all paperwork and stay organized so you can respond appropriately at each step of your case. Common criminal defense strategies against Class II felonies in Chicago. In the event that you're charged with a Class II felony, it's essential to contact a criminal defense attorney to protect your rights under Illinois law and start building your defense as soon as possible. At Combs Waterkotte, we've found several effective strategies for combating Class II felony charges. While each case and each charge is different, here are some of the most common criminal defense strategies we employ in Class II felony cases. Lack of intent. Intent is often a key component of a Class II felony charge. A lack of intent defense argues that the act was accidental or misunderstood. If prosecutors can't prove the required mental state beyond a reasonable doubt, the charge may be reduced or dismissed. This defense is especially effective in theft, drug, and property-related cases. Illegal search and seizure, Fourth Amendment violations. If police obtained their evidence through an unlawful search, that evidence may be suppressed. A Fourth Amendment defense challenges whether law enforcement had a valid warrant, probable cause, or legal justification for their search. If they didn't, a defense attorney may be able to get the charges dismissed. Self-defense. Self-defense applies when a defendant uses reasonable force to protect themselves from imminent harm. In Illinois, the force used must be proportionate to the threat faced. This defense is often raised in violent Class II felony cases like aggravated battery. It can potentially justify the defendant's actions if properly supported by the evidence. Alibi. An alibi shows that the defendant was somewhere else when the crime occurred. This often involves witness testimony, surveillance footage, or digital records. A strong alibi can create reasonable doubt and undermine the prosecution's timeline, learning to reduce charges or a full acquittal. Entrapment. Entrapment happens when law enforcement induces someone to commit a crime they wouldn't have otherwise committed. This defense focuses on proving the defendant lacked predisposition and was persuaded or pressured by police. This is commonly used in drug or undercover sting cases and can result in acquittal if successfully demonstrated in court. Duress or coercion. In a duress or coercion defense, an attorney argues that their client committed the alleged offense because they were threatened with immediate harm. To succeed, the threat must be serious and leave no reasonable opportunity to escape. This defense acknowledges that the act occurred, but it contends that it was not voluntary, which can negate criminal liability. Miranda rights violations. If law enforcement officers fail to advise a defendant of their Miranda rights before a police interview, any resulting statements may be inadmissible. This defense focuses primarily on protecting against self-incrimination. Suppressing a confession or damaging statement can significantly weaken the prosecution's case and increase the odds of a favorable outcome. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.